permission of the Vice Chancellor, may we begin, sir?
Yes, please. Oh.
Yes. Firstly, ladies and gentlemen, on behalf of the Center for Criminology, Criminal Justice and Victimology, I welcome one and all to this invigorating session with Professor Virinda Narayan, who's been there specially for us early morning out of a busy schedule. On behalf of our esteemed, dynamic and visionary Vice Chancellor, Professor Dr. G.S. Bajpai, respected, esteemed Registrar, Professor Dr. Naresh Watts, faculty, staff and students, I extend my heartiest and most warm welcome to Professor Virinda Narayan. She's going to be talking to us on feminist constitutionalism, critical trends, and is going to, in particular, take up the famous Sabarimala case, that is the Indian Young Lawyers Association versus State of Kerala. Briefly, let me tell you about her numerous achievements. Professor Virinda Narayan's research and teaching focus on constitutional law, social diversity, and feminist legal theory. She's the author of 2 books, Reclaiming the Nation, Muslim Women and the Law in India. That is the University of Toronto Press 2008, and Gender and Community, Muslim Women's Rights in India. That's also University of Toronto Press 2001. Professor Virinda Narayan is the 2017 recipient of the Canadian Institute for Administration of Justice Charles D. Gonthier Research Fellowship. She was Associate Dean Academic at the Faculty of Law from 2016 to 19. She has been deeply involved in the community with organizations like Women Living Under Muslim Laws as an executive board member. She's been the president of the Executive Committee of South Asian Women's Community Center, Montreal. She began her education in India in the famous Lady Shri Ram College, Delhi University, and did her BA Honors in History. She went on to do her LLB from Faculty of Law, Delhi University, and then her LLM from McGill University, and also her DCL from McGill University. She began her working career as a visiting research fellow at the Asian Institute Monk Center for International Studies, University of Toronto in 2006-07. Thereafter, she was the Bolton Fellow, Faculty of Law, McGill University from 2007 to 8. Then she became Assistant Professor, Faculty of Law, McGill University from 2008 to 9. Thereafter, Assistant Professor, Faculty of Law and Faculty of Arts at McGill University 2009 to 15. And then Associate Professor, Faculty of Law and Faculty of Arts, McGill University from 15 to 16. And now she's Associate Professor, Faculty of Law, McGill University 2015 till present. She's also the Associate Dean, Academic Faculty of Law, McGill University. Now, her areas of interest include constitutional law, feminist legal theory, social diversity in law, post-colonial studies and law, critical race theory. Her publications are numerous in varied public refereed journals and books and research reports and medias and blogs, and one could go on, but it would be worthy to mention some of her media interests, wherein Virinda Narayan has spoken with CBC's Mike Finnerty on the current regarding the indictment of the Canadian-Iranian scholar Homa Hudfar, who has been detained in Evan prison since March 2016. And on October 14, 2014, her interview on CJAD's The Exchange with Dave Kaufman and Malala Yousafzai receiving the Nobel Peace Prize. And of course, in 2014, her interview with Global News and Canadian Muslim hipsters defying stereotypes. So we are very honored to have you with us, Professor Virinda Narayan. And we would like to take the discussion forward on the topic that is feminist constitutionalism, critical trends. And you can begin now with your take on the litigation, that is the Indian Young Lawyers Association and others versus State of Kerala, popularly known as the Sabarimala case. I invite you now, Dr. Virinda, Professor Virinda. The stage is all yours.
Thank you very much, Professor Kamal. It's very kind of you to introduce me so generously. I want to thank the Vice Chancellor, Professor Bajpai, for inviting me, and I'm very pleased to meet everyone here today. And I do apologize again for it being a long day for you, although it's a good time for me. I'm going to speak a bit about the Sabrimala case, as you mentioned, and I'm going to first talk a bit about what feminist constitutionalism is. I'll talk a bit about the Indian Constitution. Then I'll turn to the case itself, and finally I'll conclude with a discussion to see how we can map the theoretical framework of feminist constitutionalism onto the decision in the Sabrimala case. And Professor Kamal, if I'm running out of time, please do cut me off. So I'm got my clock on to make sure I don't exceed the time. So, as the famous feminist legal scholar Catherine Bartlett wrote, feminist legal theorists must ask the so-called woman question in law. So, in today's talk, I focus on feminist constitutionalism, and following constitutional scholar Vicky Jackson, I ask the woman question with regard to constitutions and constitutional law, with the idea of examining some of the critical issues in feminist constitutionalism. I set out an introduction to feminist constitutionalism, outlined the theoretical framework, and then moved to the concrete context as I map it on to the Sabrimala decision to ask the question, can the Indian Constitution be interpreted to uphold women's substantive equality? I set out some of the core concerns of feminist constitutionalism, which in general critiques the gender-neutral lens of the traditional approach to constitutional interpretation. And I consider all these questions, as I mentioned, through the lens of the Sabrimala case. I won't go over the facts. All of you are only too familiar with the facts. Just to say that in this groundbreaking decision, what the Supreme Court did was to mediate the perceived opposition between religious freedom and gender equality to rule that the ban on temple entry was unconstitutional. So the aim of my research in this area is to understand better the place of women's equality in Indian constitutional discourse, and then to further develop an understanding of justice that will constitutionalize women's equality rights and ensure their inclusion in constitutional doctrine and discourse. So why do constitutions matter? As all of us know, and we all are lawyers, we know that constitutions are of fundamental importance. As a foundation document and as a supreme law, the recognition of women's rights and interests at the constitutional level carries far greater weight than ordinary legislation. So constitutions are critical in engendering social progress, to entrench women's equality rights, but also in structuring political institutions to ensure that women's political participation can be on an equal basis. So the inclusion in constitutional politics gives women voice and sets possibilities for future reform. And future reform meaning to have an inclusive democracy that reshapes structures. For example, we can think about women's reservation in parliament as one structural impact. And so the big question for us really is, can constitutions be an important tool in advancing women's rights? And across the globe, we've seen that constitutions have been used to promote equal rights in many areas. And I'll just briefly go over the couple of areas I want to bring to your attention, and then I'll move to the next part. So constitutions have been used to, for one, oppose the passage of discriminatory laws. Number two, constitutions have been used as a basis to challenge existing laws that violate women's equality. And number three, constitutions have also been used to encourage the passage of new legislation that can promote gender equality. And of course, we all know that it takes more than just the presence of rights in a constitution to make them real on the ground. And at the same time, there are certain limits to constitutional rights. and how they impact gender equality. And constitutional rights are just one measure of how a country values or expresses its commitment to women's equality. And at the same time, we also know that there are many countries with much older constitutions than the Indian Constitution that lacks gender-specific provisions, but do have strong gender equality in those societies. Um, at the same time, we see that daily accounts of rights violations and persistent gender equalities, and here I'm talking in the Indian context, are in contradiction to the protections we see in the Constitution itself. So that's something to keep in mind. So what's feminist constitutionalism? Feminist constitutionalism is an idea that is getting more and more traction, particularly in Canadian constitutional discourse and US constitutional discourse, and I'm hoping in Indian constitutional discourse too. So the idea is that constitutionalism means that a government can and should be legally limited in its powers, and that its authority and legitimacy depends on observing these limitations. So basically, constitutionalism engages with the institutions of the government, rights of individuals and groups, and formulates limitations on institutional powers. So I'm very interested not just in constitutional rights, but in constitutional institutions and how state power can be limited. So feminism or feminist constitutionalism engages with all of these traditional aspects of what constitutionalism is. But more specifically, it's the project of rethinking constitutional law in a way that can address feminist thought and experience, and it explores the relationship between constitutional law and feminism and challenges traditional discourse from the point of view of women's substantive equality. So the aims of feminist constitutionalism, because I think we really need to be specific. The aims of feminist constitutionalism are one, to identify and empower women's agency and to insist on women's representation in politics and constitutional law. Number two, to challenge gender neutral constitutional scholarship. Number three, to challenge women's exclusion from constitutions. And number four, to identify, sustain, and promote gender equality norms. So I think all of us could be on board with these aims. There's nothing too controversial about these aims. In terms of what constitutional feminist scholars are proposing is an agenda that is somewhere between the reality-driven experiential knowledge of feminist theory and the rigid categories of traditional constitutional law scholarship. So you might be thinking to yourself, how do we bridge these two? And indeed, it is a delicate balance between constitutional canon and then the feminist critique of that. So it raises the question for us, very interesting question, how can we negotiate the boundary between canon and critique? Can we use the master's tools to rebuild the master's house, in other words? Now I just want to turn to identifying what are the guiding principles. What are the guiding principles of feminist constitutionalism? So we know what the aims are, the inclusion of women, empowerment and agency. So the guiding principles are very much related to the aims. Number one, substantive equality. So to be concerned with equality of outcome, to say that formal equality, which is simply a matter of categorization and classification, is not enough to challenge the roots of oppression, right? So to have a substantive equality analysis means assessing how the law impacts people concretely in their everyday context, right? And to offer transformative judicial remedies and to expose how seemingly neutral laws may actually be discriminatory. Number two is intersectionality. So a lot of us have heard the buzzword. It's a very popular word, intersectionality, but we're trying to keep it grounded in the history of systemic oppression and struggle. So feminist legal analysis requires a consideration of an intersection framework and methodology. So what it does essentially is to critique a single axis approach to discrimination. So we have to see how are women discriminated against, and the intersectionality of, say, religion, ethnic minority, sexual orientation, class location. All of these things give us a fuller picture of how people, and women in particular, experience discrimination. And the idea is that it allows for a more complex, nuanced understanding of equality and allows the court to craft its response based on this daily experience. Number 3 is inclusivity, the commitment to including the perspectives of marginalized women and marginalized groups. And here maybe we can think about untouchability also in a particular context. And so it's essential to adopt a constitutional analysis that considers perspectives that have so far been excluded in traditional constitutional discourse. And the idea is to see whose interests are served, whose interests are excluded, and what areas are excluded from strict constitutional scrutiny. And here we can think about, say, religion, for example, which is excluded from constitutional scrutiny. And finally, the point that community practices, for example, that discriminate against women must be considered not as side issues, but as equally deserving of constitutional attention. And the final guiding principle is that of challenging norms, meaning to say, once we go through all of these questions, how do we revise our constitutional norms and constitutional categories so that they challenge systemic inequality? And one such assumption is the traditional distinction that we have between the public and the private spheres, where we say it's okay for there to be formal equality in the public sphere, but we know that in the Indian context, it stops short at the family. So that brings me to the Indian constitutional framework. I'm not going to spend too much time since everyone is familiar with it, but just to say that the Indian constitution was drafted as a manifesto for social change. And its drafters were conscious not only of stark inequalities imposed by the colonial rulers, but also those imposed by a hopelessly hierarchical society divided along lines of caste, religion, and gender. The Constitution also gives the judiciary the transformatory mandate to bring about social change through the enforcement of fundamental rights and to promote equality, particularly for women and oppressed castes. But we do know that despite constitutional guarantees, women's equality in India is still illusory, and the material reality of women's lives does not really show much improvement. They're also disadvantaged in terms of employment, literacy, educational employment, and of course the discriminatory religious personal laws. So we see that women's inequality has been legitimized by the constitutional paradox of formal equality in the public sphere and legitimized inequality in the sphere of family law through religious personal laws. And so what I suggest to you is that effectively women are excluded from equal citizenship. So it becomes relevant to ask about women's substantive equality in India and whether the Indian Constitution can be for women too. And I also think that it's important for us to note the current political context in India in terms of the democratic deficit, if we can say that. There is a democratic deficit in India because there's a sharp rise in executive power, diminishing judicial independence, and a lack of public confidence in democratic institutions. And perhaps we could even go so far as to say a disregard for minority rights and civil liberties, but we can keep that discussion in brackets. So I move now to the case that I want to use all of these ideas to test the case to see how does the Supreme Court of India balance religious freedom with gender equality? Can we interpret the Constitution to represent women's interests too? all the while being conscious of the fact that we have to guard against illegitimacy of judicial mandate, meaning to say that we have to be a little bit cautious about embracing too enthusiastically judicial activism. And we see that happening a lot in India, where the judiciary may be exceeding its mandate, and there are many different reasons for that, perhaps one being linked to the democratic deficit and the role of public institutions and confidence in them. So now, if I have the time, I want to go through the Sabrimala case and through that lens to consider how the Supreme Court has interpreted the Constitution in favor of women's equality rights. So we all know that we have the lone dissent being Justice Indu Malhotra, and it may seem a bit ironic that the only woman on the bench would vote against women's equality rights, and we can discuss that in the Q&A. Why does that happen, and what was her justification, and how far can we agree with her? But of particular interest to me is the use of religion and cultural morality versus constitutional morality to justify the exclusion of women from full participation in community life. So while the text and the provisions of the Constitution are very important, equally important for us as constitutional law scholars is how does the Supreme Court interpret rights guarantees? And we know that oppressive and discriminatory cultural or religious norms are often exempted from constitutional scrutiny on the ground of religious freedom. So the way in which religious morality and constitutional morality have been dichotomized has had profound consequences for women who have been denied fundamental rights on the basis of their religion or culture. And until recently, a traditional interpretation in constitutional discourse has been the misconception that religious freedom permits discrimination under personal laws to be shielded from constitutional scrutiny and legitimizing women's inequality. And here I'm referring to the Sharavano case, which everybody knows came before this one. What we see in Sabrimala is the Supreme Court is willing to weigh discriminatory religious laws and customs against constitutionally protected fundamental rights. And the significance of this case is that it upheld women's religious freedom, women's right to equality, and challenged received categories of analysis. I'm not going to go over the issues of the because we are familiar with that, but we'll just look at the decision and then we can discuss. So the majority, of course, held that the ban violated women's equality rights and the right to worship. And Justice Chandrachud was very interesting in the way in which he framed discrimination, and he contextualized women's exclusion from the temple as an aspect of structural inequality and the wider relations of domination and subordination. He questioned oppressive practices and customs rooted in a patriarchal social order and rejected the denial of equality to women on these grounds. But perhaps, at least to me, most importantly or most interestingly, he linked the constitutional prohibition of untouchability with discrimination against women. Now, Professor Fuller may be raising his eyebrows and not too enthusiastic about this part, but we'll discuss this later. So for me, most interestingly, he linked constitutional prohibition of untouchability with discrimination against women, situating this discrimination within the larger structural disadvantage. Next, Justice Chandrachud collapsed the public-private distinction by holding that temples are public institutions. Temples are public institutions, and he insisted that women's access to temples was constitutionally guaranteed. And we can see again the throwing open of Hindu temples to untouchables as well as part of this constitutional discourse. And he insisted that all discrimination must be tested against constitutional values, and any discrimination that perpetuates gender stereotypes would not withstand constitutional scrutiny. So religion and custom must yield to fundamental rights, and religious morality cannot trump constitutional morality. And finally, he linked women's equality rights with equal citizenship. So where do we see the dissent here, the lone dissent of Justice Malhotra? And in a sense, we might agree with her to the extent that the court or the judiciary should stay out of religious adjudication. Fair enough, we might agree with that. She also said that members of the religious group should be able to decide for themselves what constitutes an essential practice or an essential aspect. So to religious studies scholars, the essential practices test is something that is constitutionally very relevant here. But where I disagree with Justice Malhotra is where she said that she rejected the argument that the temple ban could be likened to the untouchability ban in Article 17 of the Constitution. And she rejected outright the idea or the contention that constitutional values should prevail over religious morality. This brings us back to the ethos of the Indian Constitution, that it was drafted as a manifesto for social change, that the judiciary does have the mandate to reform religion to introduce substantive equality. So Sabrimala is transformative because it constitutionalized women's equality rights. Justice Malhotra, on the other hand, failed to consider the exclusion of women through the lens of substantive equality or through the lens of systemic discrimination. The majority insisted that religious customs, norms, and rules must conform to constitutional values and constitutional rights. It challenged the public-private binary and undertook a purposive contextual constitutional analysis of discrimination against women. It called for an intersection framing of women's equality and rejected the use of religious freedom to justify women's inequality and insisted on women's substantive equality as an interpretive principle. Because remember, we're really interested in the interpretive principles that judges are using to respond to discrimination and exclusion. So that brings me to my concluding part. Feminist constitutionalism allows us to better assess the progress that has been made and the gaps that persist in constitutional analysis. It also aims to provide researchers and policymakers and civil society leaders with better tools to introduce gender protections where they are lacking and how to leverage them to make sure that we implement women's equality. And despite, however, the victory for women's equality rights in Sabrimala, I argue that it's still premature to celebrate because women's inclusion in constitutional discourse remains fraught and politically contingent. So I end with four recommendations regarding the inclusion of women's equality rights in Indian constitutionalism. So the first one is to identify cultural norms that are harmful, to advocate for women's equality, and it's necessary to set out the specific context in which women's equality rights must be guaranteed. And Indian women are particularly vulnerable in the areas of family law and religious personal law. But beyond private sphere contexts, I argue that women's equality must also be guaranteed in public sphere context, including political participation, democratic inclusion, employment, healthcare, and education. Recommendation number 2, to insist on substantive equality as an adjudicative principle. So having a substantive definition of equality ensures that the lived reality of women are taken into account by the judges. Number 3, recognize intersectionality as an overarching method and framework while adjudicating women's equality claims. So this kind of intersection framing should find resonance when judges are looking at the artificiality of constitutional categories and litigation strategies that force women to choose between their culture or their religion or their rights as citizens. And number 4, to challenge those norms that oppress women and perpetuate inequality. Judges' reluctance to challenge oppressive norms must be questioned and challenged. And of course, a lot of progress has been made in Sabrimala, but women's equality still has a long way to go. So ultimately, feminist constitutionalism enriches the way in which jurisprudence is shaped and analyzed. And it's important for us to keep advocating for change until these recommendations become a recognized part of the jurisprudence and decision-making process. Constitutions must take women in their multiple identities into account. Indian women, religious minority women, Dalit women, and lower caste women continue to be discriminated against. And India's constitutional guarantees must be interpreted in a way that protects all women's substantive equality and places that in the center of constitutional discourse. And I'll end there, and I thank you for listening.
Well, Professor Vitita Naran, we would like to open the house for a debate, or rather a discussion. Should I start, or should I, Siddharth, would you like to start? Or Shiva Sharda?
Ma'am, you
Okay.
please ask the questions.
Yeah, I'll start. Ma'am, Brinda ma'am, what I wanted to ask you is, how do you look at the facts that the lawyers have been filing the petition, right? They are they are gender right activists who have been working in and around Punjab. So what is your take on that?
I'm not sure I understand your question, Kamal. What do you
What I'm
mean?
trying to say is the Indian Young Lawyers Association, that they constituted of individuals who
Okay,
filed public interest litigation, and
Yeah.
they are fighting for gender rights, or gender rights activists working in and around Punjab. So was it really a public interest litigation or a publicity interest litigation?
That's a very good question. It's a very good question, and I like the way you framed it. Uh, my answer to that would be that the first I'll talk about public interest litigation and the importance of it. So I understand fully the fact that you might say that in terms of standing, they don't have the standing in terms of not being directly impacted by that temple exclusion. So my answer to that would be that the nature of public interest litigation, particularly in India, has been to democratize the constitution and to have a constitution that speaks from the bottom up, meaning to say that by relaxing the rules of standing and allowing public interest litigation, the Supreme Court can take notice of injustice that occurs anywhere in the country. And you do not have to be directly impacted in order to speak out against injustice. So that would be my answer.
But on the other hand, if you look at the impact of the ruling, like, if you do an impact assessment of the ruling, do you think it has been implemented efficaciously by the state organs? Or you can say, is there absence of equivalent will on the part of the people? That is, the women in the age group of 10 to 50, do they really want to go? Or is it an issue that is coming from outside and beyond the borders of that place? The people over there are more than happy, following those traditions. Apart from that, don't you think that the court very conveniently has ignored the peculiar nature of the deity? That is the Naistik Brahmachari, that is eternal celibate. So that has been, I feel, ignored. So there has been a controversy between Article 25 and 26.
Right.
So what's
I think that's an important controversy, and I think it's very important when we look at the progression and the evolution of Indian religious freedom jurisprudence. So I think it's a very important kind of it's an important conversation to follow. In terms of how the women themselves, there have been enough women who want to go there, want to worship at the temple, and always there will be those who oppose the expansion of rights for whatever reason. For many reasons, women are also complicit in their own oppression. And just because you're a woman doesn't necessarily mean that you're going to vote according to your gender identity, right? It depends on where you're situated.
Yes.
In terms of the Supreme Court, I think that perhaps the outgoing or the former Supreme Court Chief Justice Bobde did a disservice by calling for the review to say that we were going to review all inequality in person. So I think as a parting shot for me, that was one of the disappointments of Chief Justice Bobde's rule, if we can say that. So I think that it's important to keep our eye on the main ball, and the main ball in this case is women's substantive equality, keeping it in mind that the Constitution has allowed or mandated the judiciary to reform religion. So wherever we do find inequality, I think that it is incumbent on us to challenge that inequality wherever we find it, and not shield it on the ground of religious freedom, because we have to remember that it's a religious freedom of women too, and this is what Justice Chandrachud was trying to tell us, that religious freedom is for all members of the faith, not just certain.
Yes. I think Professor Naresh Schwartz wants to say something. He's raised his hand.
Thank you, Dr. Kamal. Very good evening to all colleagues. Professor Varinda, I have a question as a student of law. One part very wonderfully you have just discussed on the part of the constitutionality, and that too specifically you have emphasized on the patriarchal society, the status of the women. If I place it on the different node on the matriarchal society, first part is that is regarding the matrimonial home. What should be the matrimonial home? Second part is when we are talking of the matrimonial home, that is of the patriarchal society. In terms of even take it in context of the surrogacy bill which is pending in the Indian the Parliament.
Which bill, Professor Naresh? Which bill
The
is that?
surrogacy bill.
Okay, yes.
Yeah. So this question, on the other hand, like even in the Guardian in the Wards Act under Hindu law, one provision is there that the child will be under the guardianship of the parents. Priority goes to the father, but in absence of the father, then the second priority goes to the mother. So on the women perspective, I just want to have your clarification if it is on the matriarchal society. Please.
So your question is, how do these provisions fit in with the notion of patriarchy?
In the matriarchal society.
Yes, but
and
Professor,
that too on the women perspective.
Right. I think that, say, if we take the last example you gave of the Hindu law, the Guardian and Wards Act, that the guardianship goes first to the father and then only in the absence of the father passes to the mother, right? That's the point.
Correct.
And if you look at, for example, Muslim law as well, in Muslim law as well, guardianship and custody automatically passes to the father in the case of dissolution marriage. And if there is no father, it passes to the grandfather, so the paternal family. So I think that definitely what you point out is an instance of inequality. And if we look at the way in which, say, the Hindu Marriage Act has been reformed in the 50s, it is more equitable. So perhaps it's time to look at, and in fact, that is one of the aims of feminist constitutionalism, is to subject to scrutiny all of these laws to see where is it discriminatory to women and how can we make it equal. So I think that your example is a good example of one piece of legislation that can be looked at through the lens of substantive equality. In terms of the matrimonial home, I'm not sure that I understand the question well enough. Could you repeat the question.
I'll clarify. I'll
Yeah.
clarify. Like in the matter to constitute the matrimonial home, usually the trend in the
Yes.
patriarchal society, the
Yes.
bride goes to the bridegrooms.
Yes.
Okay, and
Yes.
if always this is the trend, okay, the bride has to live with the bridegroom's home.
Yes.
Can it be reversed then? Like Garjamai? Why not Garjamai then?
Right.
Why not be the why not the women perspective? That way.
Right.
My
Okay.
question is that. Yeah.
Okay. Understood. So what we're talking about here is custom, right? Custom or norm. So the norm in Indian society, most of Indian society, except if we exclude matrilineal societies, maybe in Kerala and Meghalaya, for example, the norm is for women to go to live with the in the family home, husband's family home. And can we understand that as patriarchal? I think that, Professor, we can understand it as patriarchal to the extent that we see that the head of the household is considered to be the husband, right? So if we were to turn a substantive equality lens to that, I think what it would simply mean is that what we would be interested in understanding is that how are family finances divided, for example? If we're looking at the case of marriage and divorce, how are family institutions structured in a particular way that women are considered to be unequal partners? And that's linked to your Guardianship and Wards Act, if we're talking specifically about Hindu law. How do women inherit property? Because what we're really interested in understanding is the material functionality of these laws. How does it translate into women's, say, economic empowerment, financial independence? How does it prevent violence against women? How does it prevent dowry deaths or bride burning, for example? So I think this is the lens that we have to look at. And certainly, it is a patriarchal custom. You're absolutely right.
In addition, another question here, there's the last
Yeah.
question here
Yes.
it is about the matrimonial property. What is the concept of the matrimonial property in Europe? And because we do not have as such this provision of the matrimonial property, what we are facing here, like the women who is totally devoted to the household work, and she does not have any share in the other property actually.
Yes.
Even that property is subject to the death of the husband only, then only the property will be in her account. Otherwise, rest of the property, whatever is earned by the husband, so long as it is not divided, she does not get any share there.
Right. So I think you pointed out a very important aspect of women's agency and women's empowerment. And this is one of the areas that we need to shine a light on, and we need to subject it to scrutiny. So the root of all the problems is a lack of economic empowerment for women, particularly within property law regime and family law regime. So how do we change that? One of the ways is to borrow from the idea of civil law, which we also have here in Quebec, the idea of unjust enrichment, meaning to say if the woman has contributed to the success of the husband, then that upon the dissolution of the marriage, she must get an equal share of that. And we call that concept that of unjust enrichment. But if we look at, I guess, Hindu property law, there's been some attempt to reform it as much as possible. But I think that we have to also recognize that the reach of the law, the reach of the state law is very narrow, particularly in India, where most of these family arrangements are done according to community groupings or social ordering, non-state law. And so I think we have to start with education and cultural inquiry. How do we break those cultural taboos? And I think that as lawyers, we need to look beyond the law as well. That would be my answer.
I suppose a lot of family law has come into. The
Yes.
original, actually, we are diverting from the original topic. Naresh has taken the
Yes,
debate to some other
yes.
direction.
Sir has
So,
taken it to his favorite passion,
yes, yes.
family law, which
But
is fine.
anyway, you have
But
been so modest
Sir,
to answer all those, family law questions.
Dr. Gagan wishes to make a comment. A quick
Kamalji,
comment.
your voice is
Uh,
cracking. Hello. So,
Yes, sir.
can we have? I think she has actually raised some very interesting debate about this division of functional, formal equality and substantive equality, and the core question on the top. So we can have some couple of questions. Though there are many hands, I'm afraid we may not go to all questions. I'm sure. So, can we have some core issues which were the part of delivery? Only focus. Please focus on that only. And that too
Yes.
very brief. Don't formulate a classroom like question. You know.
No.
So Kamaljeet, now let us go to some other. You have asked and narration. So can we go to who is next?
Dr. Gagan would like to say something.
Okay.
Good evening. Good evening, everyone. My comment is actually again something relating to family law only. I'm sorry. If I'm
But you please keep the question to the topic. Otherwise, it would be haywire. I'm actually keen to listen her on those issues. Keep your focus. Yes. Go ahead, please.
Feminist constitutionalism.
so
Yes.
feminist with respect to the core issue as far as family law is concerned, and more with respect to the Hindu law, we were talking about the property. Amendments have been made in the substantive law that has been provided. But the thing is that as far as the actual implementation of the law is concerned, the that is missing in the sense that if you actually go to the sociological surveys which have been conducted for the actual shares which have been given to the females, that is before their marriage itself, they are made to sign the documents that they will not ask for any share. So
Right.
even if there have been amendments or changes in the law for that matter, it is not ultimately providing the actual relief to the masses. That is one thing. And other was with respect to the divorce part. If I can comment on that, or we can
I'm
just
sorry,
continue.
Gagan. I'm actually please. This is not done. Let us have. So, Brinda, would you like to please respond to this? Again, this is very away from what you have spoken.
Yeah. No,
Please.
that's fine. I'll take that as a comment, and I'll take that as a comment to say that indeed there is a big disjuncture between rights on the paper and rights on the ground. But I think that if we try to link it back to constitutional law and constitutional interpretation, I think it's important to see that uh, in order to address the gap, you have to understand that the starting point is to have judgments like Sharabano, to have judgments like the Sabrimala decision, because constitutional law, while is concerned with the concrete reality, also is and provides a normative aspiration framework for the way we want our society to be. So I think that we have to consider it in that way, and that kind of de facto versus de jure was something we have to close the gap.
There is a question from Kushagra Gupta. Maybe.
Just a minute, Kamaljeet, hold it. Kushagra will ask first. Let's consider faculty is there. Yes, Siddharth, you want to ask something?
Thank you, ma'am, for your very insightful presentation. And it has actually made me re-evaluate my position on the untouchability concern. Nevertheless, my fundamental concern remains the same. When we read Article 17,
Yes.
we on the abolition of untouchability, we have always been taught by all constitutional law scholars that the word untouchability has been kept within single inverted commas in the Constitution. And in the debates, if we refer to discussions on Article 17, we are informed that this untouchability that 17 seeks to abolish is only concerned with the caste-generated untouchability. And Dr. Ambedkar is very clear that he is not abolishing any tuberculosis-generated untouchability, considering the fact that in 1950s, tuberculosis was quite kind of major issue. So how exactly have we reached this point? And if we if we have reached this point, do we have judicially manageable standards? Are we isn't the court exceeding its mandate too far? And aren't we reaching a situation where uh, the court will be approached by anyone and everyone seeking all sorts of remedies? For example, I can tell you a couple of immediately after this judgment, VHP, Vishwa Hindu Parishad, they approached the High Court seeking relief for Muslim women to pray side by side Muslim men in the mosque. The court just dismissed the petition. They never looked at the Sabrimala precedent. So, if you can speak on that now.
Sure. Thank you, Sujat. That's a very important question, and it gives a chance for us to try to get to the bottom of the problem. And I think the importance of Justice Chandrachud linking untouchability with the exclusion of women from the Sabrimala temple in a constitutional context. I think first we have to say, okay, even in the Constituent Assembly debates around the insertion of Article 17, they left it a bit ambiguous in terms of the definition of untouchability, whether there should be untouchability or other things should also be looked at. So that's one thing. If we look at those who made that argument, so it was not something that Justice Chandrachud himself came up with, but he was responding to the arguments made by certain petitioners. And one of those prominent in that also is Indu Jay Singh, who made that argument, and so he picked up on that. Another constitutional scholar who's also in favor of that argument is Tarun Khaitan, and he also does a lot of work on the Tarun Khaitan on anti-discrimination context. So there is this whole body of constitutional scholarship that looks at the larger context of discrimination frameworks. And so I myself, when I look at this decision, I feel that looking at it from the lens of substantive equality and looking at it from the lens of constitutional discourse, I think it's important that Justice Chandrachud makes the links that inequality and exclusion is based on stigma and taboo, right? So he links the exclusion of women based on menstruation to a stigma and taboo that is contained within religion. So not just the Hindu religion, but all religious traditions have a stigma around menstruation, whether it's Judaism, Islam, etc. So he's making that link with, can religion and biological functions be used as a basis for which to discriminate, right? And his conclusion is that if we consider the context of discrimination, either untouchability or menstruation as a biological ground, so it's an essential part of identity that cannot be changed, right? So if you looked at grounds of discrimination, whether in the Canadian Constitution, for example, where you have any identity factor that cannot be changed, same as in India, we have religion, race, all of these things. So it's an aspect of identity that cannot be changed. So that's where you have to shine the light of substantive equality. So I think it's not too far a stretch to say that the idea of taboo can be used to challenge exclusion. And that's how he did that with regard to untouchability and the Sabrimala exclusion. With regard to the second part of your question, what is the way in which the Supreme Court can dismiss or not take into account a petition which is deemed to be vexatious or mischievous or frivolous, right? So certainly the political context of the VHP now suddenly becoming the champion of Muslim women's equality rights is something that luckily and happily the Supreme Court saw through. But I think that I don't think it's a widening mandate of the judges. It's simply this is their job. Their job is to decide what is admitted, what is not admitted, and what are the grounds. So I think that we have to have that kind of healthy judicial discourse. And there's also a conversation between the legislators and the judiciary, right? So, for example, if you look at the Vishaka case, that's a classic case of the dialogue between the judiciary and the parliament. Public interest litigation, appealing to international law, Justice Verma put in his CEDAW General Recommendation 19 because there was no legislation. Years later, Parliament passed something. Now women are using that law. Same with the Shaira Bano. Whatever the motivations of Mr. Modi's government in doing that, ultimately the decision came from a public interest filed by Muslim women, heard by the Supreme Court, and then it was up to Parliament to legislate. So there is a conversation that happens between judiciary and legislature. So I would leave my answer at that.
Ma'am, if I may supplement, my
Yes.
colleague,
Just a minute.
Dr. Sangeeta.
There is a multiple
Yes.
questioning. I'll come back to you, Siddharth. Yes, Kamaljeet, go ahead. Just a
Sir,
minute. There are many people who are raising hand. We'll take one by one them. There is a certain
yes,
order.
Shiva Sharda wanted to ask a question.
Shiva Sharda. Please be brief and we'll have another 5 minutes only.
A very good evening, ma'am. It was indeed an insightful lecture that you had. I would like to have your insights on the specific reference which you mentioned, that is democratic deficit. Specifically, I would like to highlight the silences of the Constitution when it comes to status to contract, why it is applicable always on the women. And never we have ever considerate with reference to men in this case. Silences of the Constitution and democratic deficit. And also I would like to have your opinion that how it was not an internal matter of a particular religion. From the extracts of Justice Indu Malhotra, how do we negate 26 subclause B in this regard? Because why it is not an internal matter of a particular religion? I think that's all for my question. Thank you so much.
Thank you, Professor. I'm going to take your last question first, because that's for me the more interesting thing. How is it that it's an internal matter of religion that the state should not be looking at? So the first point I'll start with is the mandate in the Constitution to reform religion. It's very clear the Constitution has given that mandate to the state to reform religion in order to address discrimination along the lines of gender and caste, right? So that's the first argument, that the state does have the authority to regulate religion under Article 25, right? So religious freedom stops where the state has the authority to reform religion. What about Article 26? So it's in terms of running an institution, so endowments or work for the temple trust, etc. This particular Article 26 does not apply over here, because we have to also consider the fact that Article 25 and 26 have to be read together. Where women's equality is a fundamental right, the question is, how do you balance the fundamental right to equality with the fundamental right to religious freedom? We come to your question about, is it an internal matter of a religion? So what it raises is the interesting thing. I think the next step in the evolution of Indian religious freedom jurisprudence is to do away with the essential aspect test. So the question in Sabrimala was, is the exclusion of women from the temple an essential aspect of the Hindu religion, right? Sabrimala was not considered to be a sect, so Article 26 didn't apply. They can't make up their own rules, right? That's the short answer to your question. But in terms of whether women do not also have equality in terms of freedom of religion, that's the question. So where a religion oppresses a particular group, either women or lower caste or untouchables, it is incumbent on the state to address that inequality. If we left it to religion, then it means now we have to start understanding who makes religion. Who does religion benefit? Who makes the religious rules? How many women have been included in the interpretation of religious customs and rules? So I think this is where Justice Chandrachud's decision is also interesting, because he talks about the fact that there are a number of oppressive customs and practices that must be challenged. And it takes us back to the Constitution. It takes us back to the Narsoppa case, for example, Article 13 of the Constitution, and what is the way in which we can shield discriminatory practices. So that Narsoppa decision was good that it was overturned, but that decision had a particular results outcome because they didn't want to let bigamy for Hindu men be allowed. So that's the content. But thank you so much for the question. I'll stop there.
Thank you, ma'am.
Yes, now, if with your permission, Vrinda ma'am, can we have some students who have very eagerly posted their, questions on the chat box? Quickly, we start with Kushagra, Mehek, Jesleen, and then followed by Simran. Quickly, Kushagra.
Kamal, can we take two questions together? That may save time.
Okay, Kushagra and Mehek, please.
I think Mehak could go first and then I'll put up my question.
Actually, I was hoping you could go first because I just have an
Sure.
observation, which that's okay.
Now,
You
don't
can
waste
Sure,
time.
definitely.
Please speak.
Yeah.
Yes, sir. I extend my good evening to faculty members and a good morning to Professor. And my question pertains to where is the line that we should draw to substantive equality particularly? That is to say that if there are beneficial legislations for women, for example, maintenance, for example, non-entry of men in certain religious institutions, is that something that women should forego to forward the ideals of substantive equality? Or is it just the beneficial legislations that we go forward with?
Okay, thank you for your question. Did you want to make your comment?
Yes, Kushagra.
Yes, ma'am.
Yeah, the second comment. Ma'am has
Yes.
said take two at a time.
Yes. So my second question pertains to the aspect of outcome-based approach which you talked about in your address. And my question with that is that if reservation is provided, does that guarantee that women will stand for women rights as is evidenced, or the opposite is evidenced from Justice Indu Malhotra's dissent? So those are my two questions respectfully.
Okay. And you also had your hand up for a comment. I'll take your comment too. Ms. Bajpai.
Ma'am, I think her network is down.
Fine. Okay, I'll answer your questions then. So I think both your questions really come to the point to the same issue, the idea of what is substantive equality, what does substantive equality mean? And I think that it's important to understand that substantive equality is very important as a lens, not just for women, but indeed to look at any kind of discrimination or discriminatory intent, because the idea of substantive equality is not so much to consider discriminatory intent, but to look at what we call disparate impact. What is the impact of a particular legislation on whichever group we're looking at? So in this case, we're looking at the group of women. So what is the impact of a particular legislation on women? So it doesn't matter whether the intention was good, but we look at disparate impact. With regard to the other part of your question, I think it comes to the notion of what we call in India, but it could be affirmative action. So you have the equality provision in the Constitution, looks at equality, but also means that the state shall be permitted to make any kind of remedial programs or affirmative action programs that respond to entrenched inequality. So that may point to women, scheduled caste, religious minorities, disabled people, etc. So I think that we can't say that where there is a remedial program that benefits women, that goes against equality. On the other hand, a remedial program to benefit women is an expression of substantive equality because it recognizes that they have been historically disadvantaged, right? So the idea of historic disadvantage, perpetuation of prejudice and stereotyping. And this is the big conundrum of equality theory. What feminist theorists are saying is that women must be given equality, not just to the extent that they are the same as men, but also to the extent that they are different from men. So this is the sameness difference conundrum. And so if we can take it in the Sabrimala case, we can say that women too are members of the Hindu community. Women too are equally interested in the continuance of their faith. But the difference is that they may be menstruating. It's a biological factor. So we should take into account both aspects, right? So that is substantive equality, not just looking at classification, which is what Aristotle did, that those who are the same must be treated the same and those who are unalike must be treated unalike. That doesn't get to the root of inequality. So I think I'll end that there and I'll
Okay.
take.
Mehak, now it's your turn. Please ask.
Good morning, Professor. I don't have a question. It's more of an observation I have on this interplay between religion, gender, and adjudication in these cases. Because, of course, at one level, the case is a victory for equality rights for women. However, unlike, let's say, the triple talaq judgment, gender equality in Sabrimala judgment is not set up in direct confrontation with faith. In triple talaq, for example, while Muslim women led the challenge to the practice of triple talaq, throughout the judgment, the Muslim woman is repeatedly referred to in a protectionist language. She is represented as a long-suffering victim who needs to be rescued either by the courts or the legislature. Uh, However, in Sabrimala, the majority kind of maneuvers through this, and rather it goes into the questions of whether Ayappa devotees are a separate denomination. And the majority judgment also goes on to say that Hinduism does not profess this kind of discrimination. It cannot allow this discrimination. So, do you also see that there is probably some difference between the court's treatment of the majority religion and how it is different from court's treatment of Islam? Because whenever I read these judgments, this just comes to my mind very frequently, and kind of I'm just trying to understand this issue. So, what
Right.
are your views on this?
Okay. Thank you. Thank you for that question. It's an interesting question. And I'll answer the last part first. Of course, the political context matters. But
Right.
I should also caution us not to read the political context into these two decisions, because I believe that these two decisions, the triple talaq and the Sabrimala, were not adjudicated on a sectarian basis. So I would say that. With regard to the place of women's equality in these two decisions, Meg, I would rather say the opposite. I think that my difficulty with the Shaira Bano decision, although it was huge because it reconfirmed the overturning of Narsopha and the Article 13, it was very disappointing from a women's rights point of view because nowhere did they discuss women's equality. The only reason that there's very little discussion of Muslim women, so I don't know where you got that one from, but the basis for the decision in the triple talaq, the Sharabano case, was equality under Article 14, not equality under Article 15. So equality as anti-arbitrariness. Nowhere did Justice Nariman talk about women as women. He only talked about equality being the antithesis of arbitrary action, and he didn't like the instant triple talaq because it was arbitrary, right? In contrast to the Sabrimala decision, where it's all about equality and anti-discrimination. So have another read and look at it from that point of view.
Right.
You may like it better.
Right. Okay, ma'am.
Thank you.
Okay, now if Jasleen ma'am would like to ask.
Good evening. Thank you, Dr. Kamal. Good morning, Professor Vrinda. It was a very, very good lecture, but I just wanted to give one observation, being a sociologist. The intervention of judiciary in these cases is very typical to be observed in two terms, because religion as well as gender both are very sensitive and inseparable parts of human life. And that is, I think, perhaps everywhere in our society, in your society, in wherever we live. So I think this is what exactly has to be seen in very very typical societies whereby gender and religion both dominate the living styles to a large extent. And in just one view, ma'am, I want to know your views on this. I feel that we are lacking the theorist zeal, the theory zeal in the academics, which can be really contributive to judicial or institutional reactions and responses to these things. In India, we have very weak theoretical, the modern theoretical backup is very weak. So, what do you think? What should we do to improve on this particular thing? It is
Uh,
something which is weakness.
yes, thank you very much for your question and your comment. I think that the status of women in religion has always been, as you say, inextricably linked. You look
Yeah,
at, for example, the British justification for uh, colonial rule is to save Hindu women, right?
yeah,
From the barbaric
right.
practices of Hindu men and the Hindu religion. If you look at George Bush's justification for intervening in Afghanistan, once again, it was to save Afghan women
Yeah,
from their men, right?
right.
If
Yeah,
we look at
very
the anti-whaling laws in Quebec, where I live, once again, it's the endeavor of Quebec politicians to save Muslim women from their outdated laws. So the status of women has always been an index of civilization, and as a sociologist, it's
yeah,
nothing new to you for that.
yeah,
But in terms of how we can see that in India, in religion and in religious theory, I think that in these cases, we have a very strong women's movement in India, very strong grassroots
yeah,
women's movement compared to many
right.
other countries. And so many of the, or most of the challenges to women's inequality, we look at the Vishaka case, it was brought by public interest litigation. If we look at the Sabrimala again, and most importantly, the Sharabana case. So we have a very diligent women's movement. How does the institution respond? How will the judiciary respond? I think the judiciary has a responsibility to
Yeah,
Indian society.
exactly.
In terms of their intervention, I would just say in the judiciary's defense that they have not exceeded their role in this. On the
Yeah,
other hand, up until this time, they have not done enough for women.
yeah,
Um,
very right.
and
Very
now, when we have more progressive judges like Justice Nariman, like Justice Chandrachud, they're responding to these issues. But most
right.
important, I think, is that women lawyers have to present those arguments to the court, and only then the court can take notice of that. So that's why we have to encourage, and I always feel we need to encourage the new generation of lawyers like Professor Sangeeta, like Professor Kamal. These are the young leaders that we need to foster, and they are the ones who are going to make the change, and they are going to present the arguments to the Supreme Court. So I think that's our hope.
Wonderful, ma'am. Thank you so much. Thank you. Have a great day. Thank you.
I think now we may please, if you would permit, Shubham Shukla, he's a member of the Center for Constitutional
Thank
Law
you,
and
ma'am.
Governance.
I would be just quick.
Shubham Shukla, please, quickly.
Yes, ma'am. Quickly, I just asked, ma'am, it is the will of the deity that is being preserved by the temple through the traditions it observes, which is effectively the object of Article 26. And if you look at the Article 25, Clause 1, the deity has the right to follow his dharma like any other person because the deity is a juristic person and the state is duty bound to protect his faith. So, in light of this, the petitioner's right, don't you think that it is subservient to the rights of the deity? And the other quick question is that Hinduism is a faith which believes in diversity of spaces. In Kerala itself, we have 19,000 other Lord Ayappa temples, but it is only in one single Sabrimala temple where this practice is followed. So don't you think under the garb of equality, it is nothing but standardization?
It's nothing but what, Shubham?
Ma'am, it's nothing but standardization.
Oh,
Standard.
but
Standardization.
yes, understood. But Shubham, if standardization means equality for all, then I'm all for standardization. Because where there's even one person who is unequal, there is no equality. Equality only happens when everyone enters. When somebody is excluded, we can't talk about equality. So that would be my short answer. In response to the first part of your question, I think that in every country, in every constitution, From the beginning of time, the state has always controlled religion. The state has always regulated religion. This is nothing new. Whether we look at the way in which family law has been formulated in India, even the Special Marriage Act, everything is based on a particular understanding or definition that comes from religion. So whether it's a Judeo-Christian religion, whether it's Hinduism, etc. So there is no country in the world where state and religion are not allied in one way or the other, right? So I think that it is the duty of the state and indeed the duty of religious leaders to respond to claims for justice wherever they come from.
With your permission, can we have one last student, Simran Sabharwal?
Sure, certainly.
Thank you, ma'am. So my question is, ma'am, that we as a nation have given various judgments, like Sabrimala or allowing live-in relationships, but still we see that society has not completely accepted it. So, ma'am,
Yeah.
I would like to understand your opinion on how can we bridge the gap, that is, connect society's perception and law.
Right. Thank you. That's a very important question. I think that what we see here, what you're saying is that there's a inherent limitation to constitutional litigation. Though as constitutional lawyers, we don't like to hear that, right? There's a limitation to how much the law can penetrate into different aspects of life. And what that tells us is that if we want society to change, if we want to have transformation, it has to be outside the state legal system. It has to be in what, theorists call the non-formal public sphere. So your temple associations, your parent-teacher associations, your neighborhood clubs. Change has to come from the participation of engaged citizens in civil society. So I think that's what is essential to remember. We have to look at civil society engagement. We have to look at education. What are our schools telling our kids, right? And only then can we bridge the gap. Everybody has a role to play.
Yes, ma'am. Thank you so much for your insightful views on this, ma'am.
Thank you.
Yes, sir. Professor, our Vice Chancellor,
Yes.
Professor. Yes, sir.
Nothing but this is my job to really thank you. In the end, I know that there are many more, colleagues and students are waiting to sort of engage
Yes,
with this very, very interactive, very fruitful, productive, and thought-provoking discussion. Because probably your talk has taken us to those key questions which we as a law researcher are always willing to engage with, and probably that is why there is a lot of sort of invocation on some of these ideas. But I know because of the limitation of time we couldn't accommodate all the question. However, the issue remains that your talk has really demonstrated the basic constitutional imagination of social issues at first place at a substantive level, and second level you have tried to demonstrate the function of the institutions of the constitution. That is very important. And at third level we are looking at a very interesting interaction of judicial interpretation or judicial imagination of the constitutional vision. That is very important. And in between, I find that there is a onerous duty, or I would say very, huge sets of expectations from the judiciary to really capture the societal mood, the way we understand it, the way the cultural norms interpret a particular social issue. It is difficult to adjudicate these issues, though it is very easy to discuss, because India is a very diversified country, so much of diversity. Our ideologies are very different. We are not very easily agreeing to a situation. So in that context, this judgment on a particular issue always evokes, whose criticism. However, I wish to, recall Professor Bakshi's, phrase. He said there is always impact constituencies. He was
Yes.
using the term impact constituencies to denote the way a particular judicial pronouncement impacts certain sections of the society. And this is exactly happening. So let us understand the contextual realities, the way they impact the sections of the society. And that's why probably nobody could really comment upon the issue and the idea, the doctrine of intersectionality Professor Vinda uses. I think this is something very important. To take this further a bit, I would also say that since we are in search of various solutions through these judgments, probably we are trying to understand the empirical imperatives of these judgments. Because if Nautaj happens or Sabrimala happens, we also want to know the extent to which the ground realities have changed for the stakeholders. However, we
Yes.
do not have any way to know that, the way it is impacting. Theoretically, we understand that something has changed, but whether these judgments have changed the life of the people or not, this is an empirical question to which we have very limited understanding. And lastly, probably, as it happened in many countries, the theoretical understanding and the progressive feminist jurisprudential foundations or the works have not really, reached or made inroads to the mindset of the judiciary in many countries. Therefore, they continue to be sort of parochial or limited in certain ways. So here I feel that the jurists and the teachers have huge role. The extent to which you are able to impact the judicial imagination with regard to certain social issues, that would make a lot of difference, as it happened in the United States of America, because people are writing so forcefully. The researchers are demonstrating that legal pluralism in a very remarkable manner to be able to guide the imagination, thinking, and the pattern of judgments of the courts there. So if you want the Supreme Court to become a change agent, a lot of inputs to be made by academia, through
Yes.
empirical researches, through visible ideas. And there has to be consensus on certain ideas. I think women equality is not a debatable issue. It should not be a debatable issue, but it is a debatable issue because we find people taking positions, ideological positions. So I really, I don't want to go ahead, but this has really sparked some, ideas. So I feel that this is part one, and Brinda has to please agree to have the part two of it, actually. Because in India, the sequence become very important, sometimes. So maybe in part two you would be able to satisfy many more people who are willing to join here, and maybe we can have a good panel. It would be in the shape of panel discussion. So really, thank you so much, Professor Vinda. I'm looking forward your continued association with this university, because having taken over here, my first insistence was to really promote academics in the institution through discussion, through debates, through researches, through new ideas, and that is actually happening. So I'm really looking forward to engage with a variety of people, overseas partners in the university. As I have mentioned, we have very recently floated international visitorship scheme for the foreign experts to be sort of visiting this institution and share their ideas in terms of teaching short courses or delivering some seminars and all that. I'm sure that would help you and your colleagues and many more people in that part of the world to facilitate this academic discourse in this university. So for today, actually, I gave you a very short notice. We have been meeting on different platforms, and I heard sometime her speaking on certain issue, and then this thought remained in my mind for quite a long time. But here, when I joined, I thought, let me contact her, and she very generously responded and agreed to share her idea, that to a very awkward time for all of us. But thank you so much for your time, and all the colleagues and students who have very creatively engaged with this discussion. And I'm sure Vrinda would soon, again, maybe next time we'll have some more organized, and probably some event online or something like that our colleague would organize. There we can please have So thank you for today, your time and your energy, and with so much of humility, you responded to a lot of complex questions deviating from the core, I know. But that is how it happens in India,
Yes, I thank you. I thank you for inviting me, Professor Bajpai. Pleasure to see you again, and pleasure to meet all the people I haven't met. We'll be in touch. Thank you so much. I'll take care.
Thank you so much. Thank you so much, everybody.
Thank you, sir.
And
Thank
Siddhartha,
you.
you email me your question.
Yes. You can email
Okay?
your questions, that is good.
Email your questions.
Yes,
Goodbye.
yes.
Thank you.
Bye,
Thank you,
bye,
thank
bye.
you, ma'am. Thank you so much.
Thank you.
Thank you, ma'am.